as our guest speaker for today. Mr. Mayank Sen is an alumnus of Raffles University, Neemrana, with specialization in business and commercial laws. He has represented the university at prestigious moot court competitions, including Philip C. Jessup, Manfred Latz, and Henry Dunant, and has won accolades as well. In the university, he has been the president of the Moot Court Society and has organized two prestigious national moot court competitions as well. He was also the member of the organizing committee of the National Capacity Building Workshop on Maritime Law. Apart from his organizing capabilities, Mr. Sen also has several research publications to his credit in national and international journals of repute and has been a part of national and international seminars and conferences as well. He is currently practicing in District Court Ajmer and is mostly into civil and corporate litigation. And other than that, he is also practicing as an independent commercial arbitrator. So without wasting much time, I would request our guest speaker to enlighten us on today's topic. And I request all the participants to switch off their cameras and microphones before we begin. And in case of any questions related to the topic, kindly drop them in the chat box. The platform is all yours, sir.
Thank you, Pragya, and I would like to thank Vertex Law Chamber also for giving me this opportunity. Now, without wasting time, we should move to the topic. Okay. So earlier this year, on 8th January 2020, the Competition Commission of India has issued a report uh, uh, concluding its market study on the growing relevance of e-commerce in India. The report provides for various considerations that the stakeholders of e-commerce take into account while choosing a particular digital marketplace platform. Like for example, if we begin our topic, I would like to say that as a general consumer, when we search for any product on Amazon, Myntra, or any other marketplace, e-commerce marketplace, without using filters, we got the search preference, the first list of brands, the major brands. Like if I am searching for shoes, I will get Adidas, Nike, Reebok first, and the other brands on a list. So this is what the competition is affected by these uh, non-disclosure agreements with the market platform, e-commerce market platform, and the big brands. Like the major issue is platform neutrality. In India, this issue has gained momentum recently, but in other jurisdictions, this e-commerce and digital marketplace has already been in scrutiny. Like the European Commission in the Google search case has imposed a form of search neutrality upon Google. It is provide equal treatment to rival retailers. It's like the same. Like they have a non-disclosure agreement with the big brands, the major brands, Adidas, Nike, or other brands have a non-disclosure agreement to show their product first in the list of any search. And on the basis of such data, the Google or the other search engines provide advertisement of the same product. So this is due to the lack of transparency we have in India related to e-commerce platform. On the same lines, the CCI has recommended a platform neutrality for marketplace platforms. The distinctive position of digital marketplace in digital marketplace platforms provides an unbridled access to a pile of different category of data. All, as we all know, they have our data also. So we are on the subject of breach of data as well. On the basis of such data, they moderate our search rankings and provide us the product which is based on our search preferences or the search history. The report raised the issues of private label when a marketplace platform assume the role of marketplace as well as retailers on the same platform. This platform neutrality is the main finding of CCI. In the category of goods and food services, an overwhelming majority of the respondent sailors and restaurants raised concerns regarding platform neutrality, as the retailers are not getting the same free entry in the market. Like for the startups, especially for the startups, this is creating a barrier on entry of their market entry. In the goods space, the concern stemmed from the two broad issues. Platform own the private label product being in direct competition with other brands in the same product categories. And the second one is set of platforms preferred sellers enjoy preferential treatment from the platform. This preferential treatment is distorting the market the most. Like only the big brands are able to sustain in the market with the help of such preferential treatment by the marketplace. Like Amazon, Myntra are preferring the big brands mainly. Another concern of platform neutrality raised by the report is the preferred seller status. In this situation where the marketplace platform provides preferred seller status of certain retail for additional commissions, the report acknowledged lack of transparency. Such lack of transparency due to the non-disclosure agreements help them to gain the dominant position in the market and have the most of the market share instead of micro, small, and medium-sized enterprises in India. They also have some other restrictive trade practices or the anti-competitive agreements which restricts others from entering into the market. The major thing CCI recommended is to create a transparent mechanism for providing the product on their platform. The second main issue is platform to business contract terms. These contract terms sometimes create anti-competitive agreement, and Section 3 attack the provisions as such anti-competitive agreements have appreciable adverse effect on the competition of India. A predominant anti-competitive concern raised in this report is unfair condition imposed upon the retailer unilaterally by the marketplace platforms. These marketplace platforms provide provide some conditions and impose on the other retailers like unilateral revision of the contractual terms without asking from the other parties, the retailers. They uh, they unilaterally change the terms. They insert certain clause in the contract with the retailers, so which allowed them to unreasonably change in the contractual terms. These platform is also highlighted to be under the anti-competitive radar in the report. So, the practices of deep discounting. Practice of deep discounting is the major one. As you all know, you guys also have seen that Koyo are providing us deep discounts. They are providing the same service at a very low cost. This is also predatory pricing. For a little bit time, it is good. It is not anti-competitive in nature. But if the deep discounts is for a longer duration, then it will distort the market, as the other retailers would not be able to compete in the market. So these contractual terms, these deep discountings on market platform or e-commerce platform is distorting the market mainly. The competition is affected by the same. Competition Commission of India is investigating into the matter, and they have provided the preliminary recommendation that these contractual terms must not be hide from the other retailers. There must be some transparency in these contractual terms. The report finds that such practices create an imbalance in the bargaining power between small retailers and larger businesses and marketplace platforms. Such a position of retailers and marketplace is antithesis to competition law in India. Therefore, the report majorly recommends that the marketplace platform must carve out the method to protect the interest of all contracting parties by transparent negotiation. Transparency. Again and again, the report is emphasizing on transparency because transparent negotiation is the key for proper competition policies in India. Transparent negotiation of contractual terms, discount policies, penalties, and dispute resolution must be open to all other parties as well. Then the other major issue comes is related to the price parity clauses. There are the price parity clauses in the contract when the retailer sign with when the retailer sign with the marketplace platform. These price parity clause refers to such clauses that bar retailers from offering any better prices on competing platforms of their website. The same is also prohibited under Section 27 of Indian Contract Act. This is a type of restraint on trade. If they are providing a special price or a product on their platform, like you have seen, some electronic items are exclusively released on online platform, only on e-commerce platform. So the price which are offering, they are offering on these platforms are not able to be given on other competing platforms or on physical marketplace. So this happens due to the contractual terms they entered with the marketplace platforms. This is also distortive of competition in India, and the same is also prohibited by Section 27 of Indian Contract Act. Like, the restraint of trade cannot be imposed in any contractual term, and this is prima facie providing imposing restraint on their trade. Like, they are not been the retailers have not been able to introduce their product on such discounts on any other competing websites or on any other physical marketplace. The report highlights that the food delivery platforms and the online travel agency, again, like if we search the Oyo, we got the discounts of some big hotel chains on Oyo, and but on other websites we did not get the same. Like on Go, Go, or MakeMyTrip.com and all, we don't get the same discounts. So this is related to the platform price parity clause. This price parity clause is distorting the market, and the same is restricted by the by Indian Contract Act under Section 27. Such clause eventually lead to anti-competitive competitiveness in the market for the reason that they create barriers to entry for other platforms and lower competition incentives for platform in the market. However, on the flip side, the price parity clause can, on some on short-term basis, prevent the free riding by retailers' website and promoting competition on non-price factors. Thus, price is the main and major factor in competition law policy. This predatory pricing for longer duration will affect the competition in the market. Although the shorter duration would not affect the competition law in India, but the longer duration will lead to exiting the market by some small retailers or small businessmen, and especially for startups it will not be able to cope up with them, as they have to they have to leave the market in the initial time only. They even did not get the proper funding, as these giants, the e-commerce giants, have gathered most of the funding from Indian from domestic funders, as well as they have also gained the private equity funding from the big market investors like KKR, Blackstone, and etc. So this price parity clause is restraining them, the retailers, to introduce the same product on the same price at any other platform. Thus, the report concludes that such clause can constitute anti-competitive vertical agreements, as it has an appreciable adverse effect because it is restricting the others from entering into the market. So it has prima facie, it has appreciable adverse effect, and the same is considered as anti-competitive in nature, where the market platform exercise substantial market powers, and there are foreclosures of competition for rivals. The rivals may not have sufficient incentives to compete in the presence of such price parity clause that will lead to exiting from the work or exiting from the market. It may also lead tactic coordination amongst platforms to block deviation from commission rates. However, owning the advocates for case-by-case assessment of such practices. Thus, we cannot say that a price parity clause is in itself anti-competitive in nature. We have to examine it on the basis of the facts and the duration it imposes such price parity clause. Then the second terms of contract, which creates an anti-competitiveness in nature, is exclusive agreements. Many brands and the small retailers have exclusive agreements with the marketplace, e-commerce marketplace. Generally, the marketplace platform execute certain exclusive agreements for exclusively launching a product. As I have already told that some electronic items like smartphones are nowadays being launched on these marketplace platforms only. So on the marketplace platforms, they are restricting the other the small marketplace platform which are just connecting the buyer to seller, or are just acting as an intermediary in the supply chain, are not able to sustain in the market. Like if the brands are only exclusively launching a new product on certain website or marketplace, then the other small competitors would not be able to sustain in the market, and the competition among the e-commerce is affected by such exclusive agreements. The marketplace platform execute exclusivity agreement for exclusively launching a product, or for allowing the platform on list only one brand in one product, that is distorting the competition. These agreements clubbed with the exclusionary tactic to bar the competition can have a significant antitrust impact in the market. Such agreements lead to reduced choices and increased prices for customers. Like if a person is buying a certain product on from a certain website or e-commerce platform, he would not keep in mind the physical marketplace for the same, for purchasing the same product. However, these agreements are not per se anti-competitive. Yes, these are not prima facie competitive in nature, anti-competitive in nature, as they promote efficiency as well as competition among brands of various retailers. But on the same hand, it is affecting the competition for small retailers and small e-commerce marketplaces. Thus, due to certain efficiencies created by exclusive agreement, the report concludes again it concludes that such analysis must be based on specific case-to-case facts and circumstances. Then we move to the deep discounts. This is a major issue which the online platforms and e-commerce is facing nowadays. The discounts which generally we see that Amazon and other e-commerce platform are giving discounts at the festival season, carnival season, and you also have seen that Oyo is providing discounts to their customers throughout the season. They are not just providing such deep discounts in any festival or carnival season. They are providing throughout a long time. That's why they are under scrutiny by CCI, because they are providing a deep discount for longer duration. The report also highlights that the food delivery platforms and the online travel agency have admitted to engage in discounting their product. The same discounts is not able to be given by other small market retailers or the other small business startups and any other uh, small business which are new to the market, and this leads to exiting the market by them. The deep discounts offered by these platforms raise the concerns of differential discounting structure, leading to discrimination with retailers, ranking demotions, erosion of profitability, and brand equity loss. Uh, Due to such deep discounts, other retailers also have to reduce their cost, reduce their prices, and working on such low cost for providing their services would lead to unnecessary loss, brand loss, the equity loss, as well as brand loss for such small businesses. That's why such deep discounting is considered as anti-competitive and distorting the competition in the market. Such deep discounts are major issue which we have to deal with, because the discounts which online platforms are giving is not available on the physical market as well. However, the report further repeats that the longer duration of deep discounts can be subject to fact-intensive analysis, as they may diminish the competitive efficiency in the market. Based on the aforementioned observations, mainly, the CCI is making some move, and we're still working on the policy drafting to uh, to uh, to provide a balance between such information asymmetry and the bargaining power, which can result in a proper free market competition for all the firms, small as well as big firms. First of all, the search ranking parameters. The first thing CCI does is to ask these platforms how they provide the product to their customers. Like if a person search on the basis of any product, he will get the he will get uh, he will get the brands, such main brands in the first list before he apply filters. And also after applying filters, he sometimes get the big brands on top of his list. Such non-disclosure agreements for providing preferential preference to such sellers, the big brands who are giving large amount to these e-commerce platforms, are distorting the market so much, because the small retailers are not able to provide provide their product on the such platform. They are good on the basis of quality, and they are also cost effective, but still such e-commerce platforms are not showing them on top of the list. The marketplace platforms are directed to set out and disclose search ranking parameters in intelligible terms in their agreements, including any impact of remuneration paid by retailers. Such main sellers are providing remuneration on basis of every product. They are also giving them a huge amount on basis of annual or the quarterly turnovers. This resulting in this leads to entering them with a non-disclosure agreement with these e-commerce platform, and providing them preference over the search ranking. Uh, the other With such search ranking, they also get the data of the consumers on the basis of search history, and similarly, they share such data with the other platforms, and this lead to showing the preferences on the basis of the previous search only. Such previous search would lead to a consumer only buying from a limited choices also. Such limited choices would affect the consumer right as well as the competition in the market of e-commerce. The remuneration which was paid by these big sellers to get preferential treatment is a kind of anti-competitive agreement in nature. So, Section 3 of Competition Act 2002 is attracting such modus operandi, and it can prohibit such practices by providing e-commerce platform to show some brand neutrality or transparency in the terms of contract. Like the contract which they are having with some major firms or companies is not on the same terms and condition as they are having with the small firms. And the small firms are also facing certain other issues, as the unilateral amendment clause which these contracts have have led to certain problems for the small retailers. This is mainly regulated by data regulation. The data regulations GDPR in EU, and now we also have a bill related to data regulation. So in India, it is still a way ahead. Still, we got a proper data protection law. Uh, like in EU, there is different laws to protect the data of subject matters, the consumers. They have General Data Protection Bill of EU, regulation of EU, as well as cookie law. When we enter into any website, there is a disclaimer that these websites use cookies. Without proper permission or without properly agreeing to the terms and conditions, they save our data, and the data was then transferred to their preferred sellers, which uses the same data and give it to the other search platforms, which shows the same consumer the product which he had already seen on the other platform. So such data regulation also need to be provided in India as well. So it lead to transparent policy that must provide for detail concerning the use of data and sharing of data with third party. Now in India, like Google and the other big websites are using such data and providing it to the other sellers, they preferred sellers, to show that they uh, to advertise the same product which they have shown, or on the basis of search history they are showing the advertising the same product. Another thing which CCI has given is related to user review and rating mechanism. The marketplace platform the marketplace platform are directed to maintain a clear transparency in the publication of the user reviews and ratings. The platform must ensure that the reviews are published for verified purchasing and comply with the draft national e-commerce policy. Still, we don't have any proper e-commerce policy in India. So, still we are working on, CCI is working on that to provide a proper recommendation on the same. Market operating price, like there is being witness of new trend of cautious notice, which are being published by manufacturers entirely on their website, whereby it is uh, intimated to the public that at a large online retail portals are not part of their authorized distribution channels, because some small retailers are also making a move by moving online and providing some same product which the retailers have, the preferential retailers have. Aggrieved by the same, the like CCI is already investigating the Snapdeal while alleging that the manufacturers were preventing its authorized distributors from selling the product through online channels, and was also imposing anti-competitive condition by preventing them from selling the goods on a discount where prior permission from it. We cannot say that prior permission would be needed for such deep discounts, but if it is imposed for longer duration, for an unreasonable duration, then it is considered to be a anti-competitive practice. The other contractual terms which are leading to anti-competitive agreements, which are leading to the nature of anti-competitive agreements, are unfair contractual terms imposed by market platforms only. This has created an environment where the trust of business on platform is undermined, and they cannot expect us to have a substantial relation with the platform. We are only searching these online platforms for a proper product, and especially in tier 2 and tier 3 countries, the e-commerce growth is much more, as we don't as the tier 2 and tier 3 cities are not having proper choices. So that's why they are majorly relying on e-commerce platform. But they don't but they didn't realize that these e-commerce platforms are restricting our right to choice in the and making a proper purchase decision. As a consumer, our right is also violated, along with the competition in India. Underlying the differences between large platforms and their business users is the misalignment between their fundamental business objective. These e-commerce platforms focus on growth and on increasing the transaction volume value, or the value generated on their platform, with which essentially drives their policy. Such policy of showing the product, they call it that the algorithms are set to show the search preferences, but they have provided a kind of AI which particularly shows the preferred sellers only at the top of the list, and afterward they show the other retailers or the other business, or the other small market or the other small companies, or which have already providing the same quality of product. Thus, the major reasons why tier 2 and tier 3 cities are using such e-commerce platform has not been properly fulfilled. The business users participating in the study urged that the terms of the engagement to be fair and equitable. But these contractual terms are not prima facie fair and equitable. As we have seen, they are providing restriction on the small retailers on the basis of price parity clause, on the basis of exclusivity clause. So this is affecting the decision making power of consumers as well, and the competition in the market also. Business, especially in the service categories, also pointed out that rather this quitting trends of their decision making power, key business variable must be shifted with these intermediary platforms. Like the discounts which these platforms are giving are not basically by the retailers. These companies are providing such discounts by themselves. The first major problem which has been seen with such platform is business difference regarding their terms of engagement. They are providing such deep discounts on their own level at their own level, and not on the basis of the retailers. So such deep discounting would probably affect the physical marketplace as well. Like the other retailers would not be able to work on such conditions, and especially for service sector, it is affecting the most. Like the hotel business person are not able to sustain at such low prices. Such predatory pricing are affecting the physical marketplace the most, and some new startups which are based on the e-commerce platform idea. Like we like as a general consumer, we only know the major sites: Amazon, Myntra, or these Alibaba and all. And any startup or any new entry in the market related to e-commerce platform is not able to sustain in the market for longer term. The contracts are customized. The contracts which these retailers enter with these platforms are affecting. Look, there are there are two variables which are affected by such e-commerce policy. One is the small market platforms or startups which want to enter in the field of e-commerce, and the others are the retailers who are providing their product on these platforms. So we, as a consumer, we see that big brands as well as some small brands and MSME sector is all the sectors are going online these days. They are providing their product on digital platform. So as a general consumer, we don't know the websites, or we don't know the small market platforms or the e-commerce websites on which the MSME sector of India is introducing their product. So these Amazon, Myntra, and all other big websites or the e-commerce platform are restricting the small e-commerce platform to enter in the market. They are abusing their dominant position. So our major concern is related to such such contractual terms which are affecting the competition of MSME to introduce the same product on these websites, the major ones, and how they are restricting the other small competitors to enter in the market. The contractual terms which create a barrier on the entry of new firms is in itself is considered as anti-competitive in nature. On the basis of Section 3 only, we are finding that these contractual terms which are not made in transparency is which are not made in transparency is which are not made in transparency is leading to anti-competitive nature of such agreements. Especially the preferential treatment clause and the price parity clause in these agreements are violative of the contractual terms and the principles of contract law in India as well as competition law in India. The services provided in the accommodation food industry further avert that they are vulnerable to practice such as demotion of their appearance in search result on account of lower commission rates paid. If they are paying a low commission rate to these websites, they sometimes demote them from their appearance. they did not even show such small businesses on their websites, because only because they are not providing them huge amount or commission for their services. The other contract term that the business users in such industry segment found to be unfair imposition on the large platform was mandatory bundling of deliveries services with listing services. Such listing would result in such listing could only be done by the large firms or large scale business holders. This requires the restaurant or the service providers who want to list on a platform to also mandatorily register for platform delivery services. So, for small firms, it would not be possible to register on platform delivery services. This will affect this will lead to the abuse of dominant position by these major e-commerce platforms. Uh, India have in this year only India have started such investigation, but the other jurisdictions have already been already indulged in scrutinizing such digital marketplace. Like EU, European Union has already been in search in some cases like Google search case. They have provided proper observation that such brand neutrality must be provided by each marketplace in the jurisdiction of European Union. This is affecting the as they have provided a report titled as competition policy for the digital era. They have provided some major recommendation that such neutrality at the platform is major thing which need to be provided to ensure competition in their particular jurisdiction. Some other countries like Germany, UK, France are also investigating on the same matter, and they have provided their major findings that the personal data of consumers are being utilized by such e-commerce platforms to be given to the to be given to the preferred sellers, and on the basis of such data, the these major sellers like the big brands, again I would like to say that the big brands include Nike and Adidas, etc., provide advertisement to the cell phones or on email ID. The major deep discounts which they provide on these websites, and other coupon or other services which they provide on these websites, they provide directly on the email website, email ID, or on the cell phone number, which they gain by these e-commerce platforms. These e-commerce platform also charge from their preferred sellers as they are giving such data to them. So we need transparency regarding such usage of data as well. Like in European Union, the General Data Protection Bill has provided that the subject matter means the person whose data has been stored by these websites need to take the consent language in a plain language from the subject matter, and they also have to provide them how they will be utilizing uh, his data. In India, there is no such means of regulating such big websites or the e-commerce platform to how they will utilize the data of the consumer. And on the basis of such lack of clarity, they use the personal data and advertise the major product which they provide on top of their list to advertise on any other website or on general searches at Google or any other major e-commerce platform. The UK Competition Market Authority majorly provides uh, such digital marketplace under scrutiny on the basis of public interest test. The public interest test provided in the UK competition market says that uh, the rationale behind the test is the public interest of the society. Like the consumer rights must be protected majorly, and they majorly the competition market authority in UK majorly focus on consumer rights only and not on the competition. In India as well, the CCI is established to maintain competition and not the competitors. So, on only on the basis of Section 3 of Competition Act, they are regulating such conduct of e-commerce platform in India, as they the contract majorly the contractual terms which e-commerce market platform enter with their retailers are anti-competitive in nature. The major clauses which I have already provided, that price parity clause, exclusivity agreement, and the preferred seller agreement are distorting the market majorly. The Competition Act 2002 has provided under Section 9 that how can investigation, how can an inquiry, how an inquiry can be started in the by the Competition Commission of India. So, on the basis, the agreement is if the agreement is leading to a barrier or entry of new market participants, then it is said to be anti-competitive in nature. And the prima facie, these price parity clause, exclusivity clause, and the preferred seller clause are prima facie restricting the other small startups or the new market variables to enter in the market freely. So such freedom is not provided to small retailers in India. And in India, we need to help the medium, small, and the micro, small, and medium industry to grow properly. The government is also pushing MSME sector to grow on the digital platform. But these big giants are restricting and acting as an obstacle on growth of such MSME sector to gain momentum on digital platform as well. In response to the emerging e-commerce marketplaces, various offline sellers have adopted home deliveries and online payment option to maintain their consumer base. But the same is not properly adaptable for the small retailers, as they are not able to sustain with the deep discounts of such major websites. Some have also felt the need to go online, such MSME sector mainly have felt the need to go online and establish their own website. But again, these big companies and the major e-commerce platforms are not able to are acting as an obstacle for such establishment of their own website in the marketplace. Hence, it can be said that these major big e-commerce platforms are also abusing their dominant position, because they are providing much more consumer base, and all the retailers know that they have a proper preferences in the mind of they have set a proper preference in the mind of consumers. But on the same hand, the consumer rights, especially of tier 1 and tier 2 and tier 3 cities, are affected, because they are not getting the proper choices they want from the e-commerce platform, as their search are only tangled with the major brands only. Although they are getting some products which are they will not be able to get in the physical marketplace. The CCI, is still investigating into the matter, and they have not provided a proper finding or a proper conclusion to restrict and prohibit such practices by major e-commerce platform, and to uphold such barriers for new entrants. The biggest challenge for a new entrant will be to draw consumer attention and a consumer base in the market, which can only be done if the services offered are substantially different from those already being provided by existing marketplace, since substitutability is not high in the digital world. This e-commerce marketplace, this service is actually not substitutable, as the elasticity is low, and all the consumers are only focusing on major e-commerce platform like Amazon, Myntra, Flipkart, Snapdeal, etc. So to conclude, in the digital economy, the competition concerns are still particularly for India, the competition concerns are growing rapidly, and CCI, our watchdog of competition in India, needs to provide a proper draft related to antitrust issues which are raised by such e-commerce platforms. Thank you, and uh, I would like to. I would like if there would be any question raised by anyone.
Thank you so much, sir, for such an insightful and informative lecture. It was indeed a pleasure hearing you. We have a couple of questions from our participants. I'll read it out to you so that they can be answered. The first question that we have is, most of the e-commerce companies provide a huge discount than the physical market. Is it not an unfair trade practice?
Yes, it is an. Are you getting me? Hello.
Yes, sir, you audible.
Yes. I'm saying yes, it is the deep discounts provided by such e-commerce platforms and the other digital marketplace is distorting the market as an unfair trade practice. But CCI have already clarified that such practices for a longer duration is distortive, and each case has to be examined on the basis of fact and circumstances. Because majorly these e-commerce platforms are providing deep discounts at the time of carnival season, so that is not distortive competition of physical marketplace. Can I have the next question?
The next question is, what legal action can be taken against the e-commerce companies who deliver a low quality products than what is actually advertised?
This is related to product liability cases. These e-commerce platforms are generally connecting us with the retailers. So the case would lie if they are providing us a different product which they have shown. We can go to the consumer firm and can file a case against both the e-commerce platform and the retailer. Rights of consumers by showing them by decepting them from by decepting them from showing a low quality product with much more reviews. The CCI in the report has already stated that a mechanism has need to be drawn to provide a proper review and review policy of every product. Like most of the consumers buy product on the basis of reviews which are provided on these websites. So the e-commerce platform need to draft and provide a proper mechanism of review policies. So we only have an option of consumer form right now. CCI is not entertaining this matter. Next question.
The next question that we have is, why do people prefer e-commerce markets, B2C? Why not physical markets? Healthy competition is always welcome.
This is because of deep discounts, which as a consumer, I would like to buy a product which is available for me on a cost-effective measure. And in the physical marketplace, I would not be having to get the proper discounts which e-commerce is providing me. And also due to the exclusivity of exclusivity agreement, as I have discussed, that some products are only launched exclusively on e-commerce platform and not on physical platform. That's why as a consumer, the deep discounts and exclusively availability of some products on e-commerce is the main reason why e-commerce is preferred over the physical marketplace. Next question.
Thank you so much, sir, for clearing out the doubts that our participants had. If there are any more questions, please go ahead and ask.
Uh, is anybody would like to ask any question or have query related to e-commerce platforms?
I guess
Nobody.
that was all. Okay, we
Okay.
have one question. Could you please tell us the legal procedure involved in opening a e-commerce company?
In opening an e-commerce company, we have to take some compliance from CCI. Like first of all, you have to establish incorporate a company under Companies Act 2013. That procedure is also a lengthy one, as you have to obtain a direct identification number and other things also. So I think you should consult a company commercial advocate as the establishment of company as the establishment and incorporation of company takes a little bit time, and afterwards you have to take compliance from the authorities like the Competition Commission of India, and then you can go on. Yes, can you please repeat the question?
We have another question. How to file e-commerce case?
How to file e-commerce case? It is based on the liability which e-commerce company have. Like if you have like your right as a consumer is affected, then you have to go in the consumer form, and as a competitor, as a rival, if your right is affected, like the small group of hotels have issued a case against Oyo by referring the same to CCI, Competition Commission of India. Competition Commission of India, as a competition issue, Competition Commission of India first prima facie examine that such practices is anti-competitive in nature or not. Afterwards, if they find that prima facie case is being performed, then they direct the Director General of Competition to investigate into the matter. After the conclusion of investigation, NCLT entertained the case, and the major proceedings, the trial is started. If the Director General states in its investigation that the practices adopted by certain e-commerce platform is affecting the competition in India or not. On the basis of that, the National Company Law Tribunal will institute a case, start a proceedings against particular e-commerce platform.
We have another question. Many e-commerce companies deliver fake products. What are legal implications?
Again, I would say like this is a product liability case. You can go into the consumer firm and say that you are being deceived by the product, as the e-commerce have shown you a different product and delivered it wrong. So it is exclusively traveled by consumer firm. Competition Commission or the NCLT have no jurisdiction over such claims of product liability. Next question.
If anyone else has any more questions, please go ahead and ask. I guess that was all. Thank you so much, sir.
Thank you.
I would now like to invite Mr. Nitin Darmora, co-founder at the Vertex Law Chambers, to give a vote of thanks.
Hello everyone. So we are concluding this webinar session here. I, Nitin Darmoda, on behalf of the Vertex Law Chambers, would like to extend a very hearty and sincere thanks to our respected speaker, Mr. Mayank Sen, who shared his knowledge and experience with us and took out his valuable time from his busy schedule. I would also like to extend a special thanks to Miss Pragya for moderating this event and giving us her precious time. I would like to thank all the participants and the viewers of this event. And at last, a big thanks to our team of the Vertex Law Chambers. Thank you everyone for your contribution. And participants are requested to kindly fill the feedback form. The link is shared in the chat box. Thank you and have a nice evening.
पैक तोड़ देगी हमारा सिंगल लाइन का पैक तोड़ देगी बता रहा हूँ ना सिंगल लाइन का पैक तोड़ देगी
हाँ जी घंटा